drafting is one of the most important skills that you can have. Unfortunately, today, what has happened is that drafting has become a secondary skill. Why? Because of two reasons. Because of readily available precedents or boilerplate agreements, and because we don't have the time to honestly draft each and every document afresh. And that's a fact of the matter that we have to live with. So, why is drafting so important? Why is it such an vital skill? Why can't a computer do drafting? At least, yet, there is no computer that can draft without the skill of a good draftsman. It's important because it creates a permanent title, and the the agreement or the document that you draft will be interpreted by the court as per the existing law. And therefore, it has to encapsulate exactly what the law is. And it's important for either party to the agreement to have it a very rigid document that is not open to various kinds of interpretation. And if we see, then it's only in today's day and age that drafting has become such a quick thing. Otherwise, if you speak to any lawyer with over 20 years of experience, they'll tell you how many drafts they've gone through on the same topic. So they've gone through the clause after clause, improving it after improving it between either side to a negotiation to eventually come down to the final draft. Of course, it has to be structured in a way that the intention of the parties is clear, and it has to comply with the applicable law. Now, in terms of drafting, there are three different kinds of documents that you'll find, especially in any transaction. Initially, they're the preliminary documents. Then there are the final documents, and then you have the ancillary documents. What are the preliminary documents? These are the documents which show the intention of the parties. It's not a final document. It's more of an understanding or a letter of intent or a preliminary exchange of ideas or a concept. And many a times, preliminary documents are not binding between the parties. And we'll talk about that further. But the main reason is that it's only an expression of intent and it's not necessarily intended to be a binding contract. However, having said that, in many cases, the courts have also interpreted letters of intent, memorandums of understanding, etc., to be binding contracts. So there's no hard and fast rule. It all depends on the way in which the document has been drafted. And therefore, it is very, very important and vital how the document has been drafted.